Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the important updates regarding Delhi liquor policy case. The Supreme Court today issued notice to the Enforcement Directorate on the petition filed by Delhi Chief Minister Arvind Kejriwal against his arrest by ED in connection with the case. Today, Senior Advocate Dr. Abhishek Manu Singhvi, appearing for Kejriwal, submitted that he wanted to show some facts to shock the conscience of the court. He said that this was an unusual matter where the petitioner was not named in the ECIR or the charge sheet. He also averred that the arrest was to disable the Chief Minister from campaigning. Seeking ED's response, the court has posted the matter in the week commencing 29th April. You are aware that the Delhi Chief Minister, who is under judicial custody, has approached the top court after the Delhi High Court upheld his arrest for his alleged involvement in this controversy. In a related update, the judicial custody of Kejriwal was today extended till 23rd April. He was produced virtually before Special Judge Kaveri Baweja of the Rouse Avenue Courts on the expiry of his judicial custody. Further, in another related development, the same court has remanded BRS leader K. Kavitha to judicial custody also till 23rd April in the case registered by the CBI over the alleged liquor policy scam. Also, the same court today heard the second bail pleas filed by Aam Aadmi Party leader Manish Sisodia. Special Counsel Zohaib Hussain, representing the Enforcement Directorate, opposed the bail plea. He told the court that the policy was meant to be an evergreen vehicle for generating illegal gains. He said that the policy was not only meant for the period it was implemented, but also for future generations. This matter will now be heard on 20th April. For detailed information, you can visit livelaw.in. Coming to the controversy related to Mughal Emperor Aurangzeb-era Shahi Idgah Mosque at Mathura, which is alleged to have been built after demolishing a temple at the birthplace of Lord Krishna. The Supreme Court bench of Justices Sanjeev Khanna and Dipankar Datta today heard the special leave petitions filed by the Management Committee of the Shahi Idgah Mosque and the Uttar Pradesh Sunni Central Waqf Board, challenging respectively two orders of the Allahabad High Court. The first SLP challenges the May 2023 order by which the High Court transferred to itself all suits pending over the land dispute before the Mathura Court. And the second SLP challenges the December 2023 order allowing appointment of a court commissioner to inspect the mosque. The court today posted the petitions to August this year. Also, earlier this year, the top court had stayed the implementation of the High Court order which appointed the commission to inspect the mosque. Today, the bench stated that the interim order will continue to operate till the next date of hearing. The court also clarified that it had not stayed the proceedings in the suits pending in the High Court. A group of retired Supreme Court and High Court judges have jointly penned a letter to the Chief Justice of India expressing their concern about attempts by certain factions to undermine the judiciary through pressure and misinformation. They emphasized the need to protect judicial independence and autonomy from political influences and false information. Amongst the signatories to the letter were the former Supreme Court judges such as Justices Deepak Verma, Krishna Murari, Dinesh Maheshwari and M.R. Shah. They urged the Supreme Court to fortify against such pressures and uphold the integrity of the legal system. Additionally, the letter states that they stand in solidarity with the judiciary and offer support to maintain its dignity, integrity, and impartiality. Let me tell you, 2 weeks ago, a group of lawyers, including Senior Advocate Harish Salve, SCB President Dr. Adish Agrawala, etc., had also written a similar letter to the Chief Justice of India. The Supreme Court today refused to entertain the petition filed by Aam Aadmi Party MLA Amanatullah Khan against the dismissal of his anticipatory bail by the Delhi High Court in a money laundering case. The case relates to the alleged irregularities in the Delhi Waqf Board recruitment during Khan's chairmanship. His counsel submitted that in January, a charge sheet was filed against 4 persons, 4 of whom were arrested in this case. However, Khan was not formally arraigned in those charge sheets. but the court categorically stated that repeated summons had been issued and Khan chose to not respond. However, the bench of Justices Sanjeev Khanna and Dipankar Datta expressed their reservations with regard to certain observations on merits of the matter made by the Delhi High Court in the impugned judgment. The court clarified that the observations would not be treated as findings on merits relating to the evidence or material relied upon by the Enforcement Directorate. The court also granted relief to Khan against an application filed by Enforcement Directorate before the Special Court for the issuance of a non-bailable warrant against him. However, this is subject to Khan's appearance before the probe agency on 18th April. The Supreme Court has disposed of a PIL regarding implementation of anti-collision measures or the Kavach system in Indian Railways. The PIL was filed following the Balasore train accident last year where more than 280 people lost their lives after 3 trains collided with each other. The PIL sought improvement of the anti-collision measures in railways. On the last date of the hearing, the court requested the Attorney General to appraise it about the steps taken so far by the government in this regard. Today, while referring to the status report submitted by the union, the bench comprising Justices Surya Kant and K.V. Vishwanathan said that there appears to be a lot of work towards the implementation of the security system in trains. The bench appreciated and noted improvements such as safety systems, track quality, staff training, and maintenance reforms. It observed that the railways are committed to implementing the Kavach system. And now let me tell you, the Supreme Court has declined to entertain a petition seeking voting arrangements for approximately 18,000 people who got displaced from Manipur due to the ethnic clash to cast their votes in their home constituency in the Lok Sabha general elections, which are scheduled to take place on 19th and 26th April. The bench led by CJI Chandrachud and comprising Justices J.B. Pardewala and Manoj Mishra observed that it would not be practical to direct the Election Commission of India to make accommodations for the internally displaced persons 3 days before the commencement of the general elections in Manipur. The court noted that the ECI had on 29th February issued a scheme of voting of IDPs within Manipur at transitory camps. But the petitioner's plea seeking directions specifically for IDPs outside of Manipur had come at a very belated stage despite being aware of the said scheme formulated in February. The court also rejected petitioner's contention for voting relief on parity with Kashmiri migrants unfounded. In another update, a petition has been filed before the Delhi High Court seeking action against Prime Minister Narendra Modi for allegedly seeking votes for the Bharatiya Janata Party in the name of Hindu as well as Sikh deities in place of worships. The plea has been moved by a lawyer who is aggrieved by the Prime Minister's speech delivered on 9th April in Uttar Pradesh. He seeks a direction on the Election Commission of India to disqualify the Prime Minister from elections for 6 years under the Representation of Peoples Act. A further direction is sought to restrain him from seeking votes in the name of religious deities and places of worship. He also states that he filed a complaint earlier this month before the ECI, but till date no action had been taken. And lastly, the Madhya Pradesh High Court has observed that if the husband objects to the wife's act of financially supporting her parents, the same would amount to cruelty. These observations were made by the bench of Justices Rohit Arya and Sanjeev S. Kalgaonkar while dismissing the husband's appeal challenging the family court's order by which divorce was granted to the wife. The court also took into account the fact that more than 15 years had passed by since both of them had been living separately, and the efforts made by the High Court for amicable settlement at the instance of the husband had also resulted in vain. The court also added that making complaints to wife's employers constitutes treating the wife as a slave, stripping her of her own identity, thus constituting cruelty. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.